Bar Rules Series. Contracts.
Applicable law. The Uniform Commercial Code, UCC, governs contracts for the sale of goods. Goods are tangible movable property. There are special rules for merchants who deal in goods of the kind, or have special knowledge or skill regarding the goods involved. All other contracts, commonly for services or real estate, are governed by the common law. Formation. A valid contract requires an offer, acceptance, and consideration. Offer. An offer is 1. A manifestation of willingness to enter into a bargain. 2. Which creates the power of acceptance in the offeree. There must be 3. Definite and certain terms that allow the contract to be enforced, including quantity, time, identification of the parties, price, and subject matter. Under the UCC, some of these terms can be filled by gap fillers. Termination of offer. Rejection. A rejection by the offeree terminates the offer. Counteroffer. A counteroffer made by the offeree serves as a rejection and the making of a new offer. Lapse. An offer lapses at the end of the stated time, or if no time is stated, then after a reasonable time. An oral offer typically lapses at the end of the conversation. Death. An offer automatically terminates upon the death or incapacity of either the offerer or offeree. Revocation. An offerer can revoke an offer at any time before acceptance. Such revocation is made by unambiguous words or conduct that is inconsistent with assent to the contract of which the offeree is aware. Exceptions to revocation. UCC firm offer. An offer made by a merchant in a signed writing that gives assurance it will be held open for a specified time is irrevocable for the stated time, not to exceed 3 months. Consideration is not required. Option contract. An option contract grants the offeree a specified time period in which to accept the offer, during which time the offer is irrevocable. Consideration is required, and the contract remains open for the stated option time period. Initiation or part performance. In a unilateral contract, the offer is temporarily irrevocable if the offeree has made preparations to perform in detrimental reliance, or has actually begun performance. In a bilateral contract, making preparations for performance may make the offer irrevocable only if the offerer induced the offeree's substantial action or forbearance before acceptance. Acceptance. An acceptance is a manifestation of assent to the terms of the offer, made in the manner required by the offerer. If no manner is stated, then the acceptance can be in any manner reasonable under the circumstances. In a unilateral contract, acceptance is made by complete performance. In a bilateral contract, acceptance is made by a return promise. Mailbox rule. An acceptance made through mailing is effective on dispatch, when the letter is out of the offeree's control. If a rejection is sent first, then the acceptance will be effective only if received before the rejection. Mirror image rule. Under the common law, the acceptance must reflect the mirror image of the offer. Any deviation is construed as a counteroffer. Deviant acceptance under the UCC 2-207 Battle of the Forms. Any expression of acceptance or written confirmation will serve as an acceptance, even if there are additional or different terms. Contrasts with common law mirror image rule. Additional terms. If both parties are merchants, the additional terms become part of the contract unless 1. The offer expressly limits acceptance to its terms. 2. The additional terms result in a material alteration in the contract. Or 3. The offerer timely objects. If either party is not a merchant, then the additional terms become proposals and do not become part of the contract. unless the other party assents. Different terms. If the acceptance has terms that are different from the offer, the majority of jurisdictions apply the knockout rule, which cancels the conflicting terms and uses gap fillers to supply the missing terms. A minority of jurisdictions treat the terms as proposals for additional terms, or treat the offeror's terms as controlling. Insufficient writings. If the writings are insufficient to form a valid contract, the parties' conduct may establish a contract. Contract implied in fact. Only the terms which agree form the contract. Acceptance by shipment under the UCC 2-206. An offer to buy goods may be accepted by shipping the goods. Analogous to performance under a unilateral contract, the shipping of conforming goods is an acceptance. The shipping of nonconforming goods depends on whether the seller acknowledges the nonconformity. If the seller does not acknowledge, the shipment is considered both an acceptance and a simultaneous breach. If the seller acknowledges, then the shipment is not considered an acceptance but a counteroffer, that the recipient is free to accept or reject. Consideration. Consideration is the bargain for exchange of legal detriment. Each party must induce the other. An agreement is not enforceable unless there is consideration on both sides of the agreement. Failed consideration. Illusory promise. A promise to perform which grants the promisor unfettered discretion over whether or not to perform is invalid consideration. Good faith. A promise to perform to the best of one's ability is valid consideration. Output requirement. An output or requirement contract may appear illusory, but it is not because the duty of good faith requires both parties to use their best efforts. Past consideration. A promise to perform for a benefit already received does not provide current consideration. Pre-existing duty. A promise to perform a duty that one is already legally obligated to do does not provide consideration. Gift. A promise to make a gift is unsupported by consideration and is not enforceable. Promissory estoppel. A promise, such as a gift, may be enforced under equity if 1. The promise foreseeably induces reliance, and 2. The party reasonably relies on that promise to their detriment. The doctrine serves as a substitute when consideration is lacking, but enforcement of the promise may be limited to the extent required to avoid inequity. Defenses to contract formation. Statute of frauds. The statute of frauds requires that certain types of contracts 1. Must be in writing, 2. Contain the essential terms, and 3. Be signed by the party against whom enforcement is sought. It applies to contracts pertaining to marriage, real estate, promises to pay the debt of another, contracts that last more than 1 year, and the sale of goods for $500 or more. Mr. Dog. Exceptions to statute of frauds. A certain contract which fails to meet the writing requirement will nevertheless be enforceable. Under common law, it includes 1. Full performance of service contract that cannot be fully performed within 1 year. 2. Admission during judicial proceeding. 3. A real property contract that seller has conveyed or buyer partially performed. 2. Of payment, improvement, possession. 4. Surety's own benefit. Under UCC, a writing is not required for the sale of goods for $500 or more, including 1. Performance to the extent that the buyer accepted or paid for the goods. 2. Admission during judicial proceeding. 3. Written merchant's confirmatory memo where there is oral contract between two merchants. One party sent signed confirmatory memo, can be letterhead, and the other does not object within 10 days. 4. Specially manufactured goods. Equitable estoppel. when an aggrieved party acted in reasonable detrimental reliance on the conduct of the other party. The statute of frauds may be avoided in the interest of justice. Misrepresentation. A misrepresentation is 1. A false statement of material fact. 2. Upon which the aggrieved party actually and justifiably relied. And 3. Which resulted in damages. Fraud is an intentional misrepresentation. Knowledge of falsity plus intent to induce reliance. Intentional. 4. Made knowingly or recklessly. 5. Intent to induce reliance. Unconscionability. Unconscionability requires both substantive and procedural unfairness that results in a contract so unfavorable that the court will not enforce it. Substantive unfairness relates to the unfairness of the actual terms. Procedural unfairness relates to the unequal bargaining power of the two parties. Duress, undue influence. A contract is voidable for duress or undue influence if a party enters into the contract as a result of a wrongful threat or unfair persuasion that deprives them of their free will. Mutual mistake. A contract is voidable if 1. Both parties are mistaken as to a basic assumption. 2. Which had a material effect on the deal. Parties would not have signed if they were not mistaken. And 3. The adversely affected party did not assume the risk. Unilateral mistake. A contract is voidable by the mistaken party if 1. That party is mistaken as to a basic assumption. 2. Which had a material effect on the deal. And 3. Where the mistaken party did not assume the risk. In addition, some jurisdictions, such as California, require that the non-mistaken party knew or should have known of the mistake, and played a role in propagating it. Illegality. Courts will not enforce contracts for illegal activities. Terms. Condition versus promise. A condition is an event that must occur before performance is due. An express condition requires strict performance, and if not met, performance is excused. A promise, on the other hand, is subject to substantial performance. Where unclear, courts prefer to find that a term is a promise, and not a condition, in order to maintain the contract. Waiver. The party benefiting from the condition may waive its occurrence. Parole evidence rule. The parole evidence rule limits the admissibility of extrinsic evidence of communications made before or at the time of a signed written contract as part of the agreement. If the contract is fully integrated, extrinsic evidence is not allowed. If the contract is partially integrated, extrinsic evidence is allowed to supplement, but not contradict the contract. Additional consistent terms. Fully integrated contract. A fully integrated contract is one that is meant to include all details of the agreement. It is generally established by the use of a merger clause, which expressly states the party's intention to make the contract the complete and final expression of the agreement. Exceptions to allow parole evidence. However, there are exceptions. Parole evidence is admissible. 1. To establish a defense to contract formation. 2. To show that there was condition precedent. And 3. To clarify or interpret ambiguous terms. Under the UCC, even if not ambiguous, course of performance, course of dealing and trade usage is admissible to explain or supplement a written contract. They cannot contradict the explicit terms of the contract. Modifications. A modification is an agreed change to a term of the contract. An oral modification is allowed, unless the contract as modified triggers the statute of frauds. Under the common law, consideration is required. Under the UCC, consideration is not required. Third-party beneficiary. A third-party beneficiary is one whom a party intends to benefit by the contract. but is not a party to the contract. An intended beneficiary can sue to enforce the contract, but only after their rights have vested. An incidental beneficiary cannot sue to enforce. Vesting of rights occurs when the third party 1. Acts in reliance, 2. Assents to the contract, or 3. Sues on the contract. The contract can be modified prior to vesting. Warranties. A warranty is a promise made by a party regarding the subject matter of the contract. Failure to satisfy the warranty is a breach. Express. An express warranty is a warranty that is explicitly stated in the contract. Implied warranty of merchantability. All goods for sale carry an implied warranty that the goods will be fit for their ordinary purpose. The warranty may be disclaimed by stating that the goods are sold as is. Implied warranty of fitness for a particular purpose. When a buyer relies on a seller's judgment in selecting a particular good for a particular purpose, there is an implied warranty that the good will perform for that purpose. The warranty may be disclaimed but only if it is in writing and conspicuous. Implied covenant of good faith and fair dealing. All contracts inherently warrant good faith and fair dealing by the parties. Assignment of rights. A promisee may assign their rights under a contract to a third party, unless the assignment would materially change the obliger's duties, or increase the burden of performance. Delegation. A party required to perform under the contract may delegate their duties to another performer, unless the performance involves a special skill. The original performer is still liable under the contract unless a novation occurs. Novation. A novation occurs when all parties, including the obligee, agree to substitute a new party to perform in place of an original party. The novation discharges the original party from further obligations under the contract. Breach. Material breach. A material breach occurs when the breaching party fails to substantially perform their duty under the contract. Under common law, the non-breaching party's performance is excused. Minor breach. A minor breach occurs when the breaching party provides substantial but not full performance. Under common law, the non-breaching party must still perform but can sue for damages. UCC Perfect Tender Rule. Under the UCC, the selling party in a single delivery contract must deliver fully conforming goods. If the goods fail to conform in any respect, the buyer has the choice of 1. Rejecting the whole, 2. Accepting the whole, or 3. Accepting any commercial unit and rejecting the rest. In an installment contract, a contract with more than one delivery, the perfect tender rule does not apply and the seller must substantially perform. Seller's right to cure. If a seller delivers non-conforming goods, the seller may cure before performance is due if the seller gives notice to the buyer and makes a timely delivery of conforming goods. Tender may occur after performance is due if the seller has a reasonable belief that this would be acceptable to the buyer. Anticipatory repudiation. An anticipatory repudiation is an unequivocal expression of intent not to perform under the contract made before the time for performance is due. The non-repudiating party has the option to 1. Sue immediately for breach, 2. Suspend performance and wait for the time of performance, 3. Treat as an offer to rescind, or 4. Urge performance and sue later. Reasonable grounds for insecurity. When the conduct of the party is not enough to rise to the level of an unequivocal intent not to perform but does give reasonable grounds for insecurity that the performance will not occur, the insecure party can make a written demand for assurances. If such assurances are not provided within a reasonable time, 30 days, the insecure party may now treat it as an anticipatory repudiation. Accord and satisfaction. An accord is an agreement to render substitute performance. Consideration is required. Satisfaction completes the substitute performance and discharges the original duty. Similar to modification. Defenses to performance. A defense to performance discharges the duty to perform under a valid contract. Impossibility, impracticability. Performance is discharged when 1. An unforeseeable event, 2. Of which neither party assumed the risk, 3. Renders performance impossible or unreasonably difficult. Financial losses are usually insufficient to establish impracticability. Whether hardship is usually foreseeable or one party reasonably assumed the risk. Frustration of purpose. Performance is discharged when the party's purpose for entering the contract is completely negated by unforeseeable events. Waiver. An aggrieved party may waive performance by the other party. Remedies. Damages at law. In contract, the goal of damages is to place the non-breaching party in the position they would have been in had the contract been properly performed. This gives the plaintiff 1. The measure of the benefit of the contract, expectation, plus 2. Consequential and incidental damages, reduced by 3. Saved cost or loss, 4. Any damages could have mitigated with reasonable effort. Expectation damages. Expectation damages aim to put plaintiff in the position he would have been in had the contract not been breached. Expectation damages measure the benefit of the bargain. For the sale of property, this is typically measured by the difference between the fair market or cover price and the contract price. For services not rendered, this is typically measured by the cost of substitute performance. Consequential, incidental damages. Consequential damages are losses unique to the plaintiff and typically involve lost profits or loss of use. Incidental damages are those losses caused by the breach in order to obtain cover or mitigate harm. These damages are added to the expectation damages. Reliance damages. Reliance damages are those costs spent in preparation for performance, or in anticipation of the other party's performance, and they are not added to the damages. However, reliance damages are alternative measure of damages when expectation damages cannot be established. Liquidated damages. As an alternative to calculating expectation damages, the parties may stipulate the measure of damages in the event of breach. Such measure must be a reasonable approximation of the anticipated loss and not punitive. Limitations to damages. All damages are subject to limitations due to certainty, causation, foreseeability, and mitigation. Certainty requires that the losses be measured with reasonable certainty and not too speculative. Lost business profits can be reasonably estimated from past performance, but are likely not recoverable for a new business with no track record. Causation requires that the breach actually caused the loss. Foreseeability. In tort, foreseeability mirrors the proximate causation analysis and requires that the harm be a reasonably foreseeable consequence of the defendant's conduct. In contract, the rule of Hadley requires that the loss was within the contemplation of the parties at the time of contracting. Avoidable consequences. A plaintiff is required to take reasonable steps to mitigate damages, such as obtaining cover or substitute performance.